Thank you very much for joining us tonight for the 7th session of our seminar. And thank you very much to Professor Tuori from the University of Helsinki to join us. Professor Tuori was supposed to be in Oxford in Trinity term, if I'm not mistaken,
yes.
for the DDG. Unfortunately, it could not happen. So thank you so much for joining us in these new formats in this term. Before we turn to your presentation, just some practicalities. You're very welcome to ask a question to the speaker during the talk. Just write it down in the public chat. I guess by now everyone is very used to Zoom, but just, the chat box is just down your screen. And you can ask a question, just start it with a Q and the raft topic of the question so that we can organize a discussion afterwards. If you're encountering any technical difficulty, just reach out to me or to Sebastian, who's also governor of the group. Or to Steiny, who's also an ex-governor of the group, who's very kindly helping us tonight. And lastly, if your audio is not working, please don't hesitate to write down your full question either in the public chat or in a private chat to me, and I will be very happy to read it out loud for everyone to share your question. I hope it's enough. Oh, a last thing maybe, if ever everything collapsed, please just click again on the Zoom link after some minutes and we'll gather again to continue the discussion. And last information, the discussion is going to be, not the discussion, the presentation is going to be recorded, but we'll stop it for the Q&A. And I guess now it's so, Professor Tuori, you have the floor for about 30 minutes, if that's okay?
Yeah, that's fine. Okay, thank you, Cecile, for the introduction and also for the invitation. As I already said, I would have preferred to come to personally to come to Oxford, but let's try this way as a substitute. My talk concerns a book, a manuscript that I am just about to submit to my publisher. The title of the book is Laws, Properties, Modern Law and After. And the properties that I discuss in the book are actually 5. The introduction is about evasiveness, how difficult it is to present a theory of law which covers all the aspects and all the dimensions of law. And I try to also to explicate the main reasons for this evasiveness in the introduction. Then come 3 parts with the titles normativity, sociality, and plurality. Normativity and sociality are also about the 3 modes of existence of law, as I call them. There is the normative dimension, law as a normative legal order, and there is a social dimension which I examine with the help of a theory of social practices. I examine law as social practices, as social legal practices. First order social legal practices where the law is realized, and second order specialized legal practices where the law as a normative legal order is reproduced and which also intervene if realization of law in the first order social legal practices confronts problems. Second order legal practices such as, for example, the main legal practices of modern law, first, of course, are first legislation, secondly judicial practices, and what for me is especially important, also legal scholarship. I also treat legal scholarship as a legal practice, and here I differ from, for example, both Kelsen and Hart. And the third part of the manuscript or the coming book deals with the plurality of law. And this part also has a very important task to fulfill. One of the tasks that this part 3 is supposed to fulfill is to show that what we call, or I call, modern state law is only one historical type of law, that there has been law before modern state law, that there probably will be law after modern state law, and that there also exists law alongside modern state law. And here I criticize criticize legal positivism for its, let's say, universalism. Legal positivism maintains that it is dealing with law in general, and that it is presenting conceptual truth about law, while it, in my mind, is only addressing one specific historical type of law, namely modern state law. And then in the epilogue, which is where you have the third property, in the epilogue, I discuss uncertainty of the future of law. The title is Uncertainty or Incertitude. And here I discuss one especially one important trend of the development of law, which we already can perceive, but which perhaps has been underestimated, and that is digitalization of law. This is for me a very important megatrend, which really is revolutionizing both law and the way we think about law. But of course, the discussion of this very important issue is very short at the end of the book. One of the issues which are the reasons for why law is so evasive, why it is so different to cover all law in a legal theoretical presentation, is what I call perspectivism of law. And in a specific subsection in my manuscript or coming book, I deal with different manifestations of the inherent perspectivism of law. It's important to note that I am discussing perspectivism in law, not perspectivism on law, so that the discussion should not be confused, for example, with Hart's distinction between internal and external perspectives. What I'm discussing is really the inherent perspectivism of law. And I start with a quite strong claim, namely that law actually, in a very fundamental sense, does not exist in itself, but only as seen from a particular perspective. And the perspective from which one looks at law impacts what one sees, what law one sees, and how one conceives of law. And maybe the most fundamental perspectivism inherent in law is the perspectivism which separates the law of legal professionals from the law of legal laymen. Legal professionals always look at law through their specific legal cultural preconceptions, through the legal concepts, through the legal principles, through the legal ways of arguing and reasoning, which we have internalized in our legal forverständnis, if you allow the German term for preconceptions. Forverständnis, a term of German hermeneutics. Legal laymen do not possess the same forverständnis as we legal professionals, and that's why they see the law differently, or they see a different law than from what we see. But also among legal professionals, there are different perspectives on law. And I make a distinction between actually three kinds of perspectivism. First, there is what I call perspectivism of legal roles. Different types of legal professionals look differently at law and see a different law. A judge looks at the law differently from a let's say a legislative expert drafting a new statute, or from a legal scholar. We have the perspectivism of legal roles, the perspectivism of judges, the perspectivism of legislative experts, the perspectivism of legal scholars, the perspectivism of legal counselors who look at the law through the interests of the clients, etc. The role we are occupying as a legal professional impacts what we see, what kind of law we see, and what features of law we emphasize, etc. Then secondly, there is what I call perspectivism of legal disciplines. Usually we are specialized, also we as legal scholars, we usually have a background in a specific field of positive law. I'm a constitutional lawyer or a administrative lawyer by my background, and it certainly affects also how I see the law when I act in my role as a legal theorist. Different legal disciplines, which corresponds to different fields of law, criminal law, private law, constitutional law, etc., have their own legal cultural specificities. They have their own legal concepts. They have their own legal principles, etc. So that, let's say, an international lawyer looks at the law differently from, let's say, a criminal lawyer. This you can see, for example, in the discussion on well, I don't know whether I dare say the word EU law in this context, but on the discussion on EU law, you can see this very clearly, because EU lawyers too have a different background, national background, and come to EU law from different fields of law with a different legal cultural package. So that's the second time of perspectivism, which separates the law of different legal professionals. And the third type of perspectivism among legal professionals is what I call perspectivism of legal orders. And this was a perspectivism which Kelsen, of course, very clearly noticed. For Kelsen, everything we say about law relates to a specific positive legal order which is submitted to a particular basic norm. So that Kelsen's positive perspectivism of legal orders ultimately was perspectivism of different basic norms, of different Grundnorms. I would very much like to give a legal cultural twist to Kelsen's understanding of the perspectivism of legal orders, and even maintain that what Kelsen was after was reconstructing the förförståndnis, the legal förförståndnis through which lawyers, legal professional approach the law. But my criticism of Kelsen here is that Kelsen first understood or discussed this förförståndnis of legal professionals, their perspectivism of legal orders in too narrow terms, only in epistemological terms, and in a way ignored, let's say, the normative dimension or the principle related dimension of legal förförståndnis and legal culture. And my second criticism of Kelsen is that he approached the förförståndnis of legal professionals in totally ahistorical terms through the notion of the Grundnorm and the associated idea of a hierarchically structured legal order. And for example, the hierarchy of the normative legal order, which Kelsen so much emphasized, is typically a phenomenon of modern state law, an idea which didn't exist before modern state law. So we have a perspectivism of legal roles, we have a perspectivism of legal disciplines or legal fields, and then we also have a perspectivism of legal orders. I want to interpret all these three kinds of legal perspectivism in legal cultural terms. At issue are legal cultural differences, which function through the förförståndnis, the preconceptions of legal professionals. But at the same time, I want to emphasize that we shouldn't exaggerate the differences, the different perspectives and their impacts on what kind of law we see from when occupying different roles, when having had our specialization in different fields, and when working in under different legal orders and in different legal regimes. There are also, of course, legal cultural commonalities which make it possible that judges can discuss with legal scholars, that legal scholars can discuss with legislative experts. There are, of course, legal cultural commonalities so that criminal lawyers can discuss with international lawyers, and there are legal cultural commonalities so that French lawyers can discuss with Finnish lawyers, etc. We can speak also very cautious, although very cautiously, of a common legal deep culture which enables these dialogical relations, cross-border, cross-boundary dialogical relations. I also discuss the perspectivism of legal theory, or the perspective of a legal theorist. And here my point is that in relation to such legal practices as, for example, judicial practices or legal scholarship or legislative practices, legal theory is a second-order practice, a second-order activity, which looks at the law adapts to the law, the perspective of certain first-order legal practice, so that legal theorists can look at the law from the perspective of a judge, of a legal scholar, or even from the perspective of a legislative expert. And we have of course examples here. Hart and the Hartians typically look at the law from the perspective of the judge. That is their privileged perspective. Kelsen, on the other hand, looks at law from the perspective of and theorizes the law from the perspective of a legal scholar. His privileged practice is actually legal science. And there are also examples of legal theory which adapts the perspective of legislative practices, the perspective of a legislative expert. We have had attempts, I can't say that they have been very successful, to develop a legal theory from that perspective, a legal theory which calls itself in German Gesetzgebungslehre, and in English it has been called jurisprudence. But there is, of course, the possibility to try to combine various perspectives, and in that sense try to rise above these particular first order perspectives and adopt a more comprehensive perspective. And perhaps my ambitions in the manuscript lie in that direction. But at the same time, I try to be aware and remind myself of the fact that nobody can be totally reflexive with regard to his preconceptions and with regard to his forefestens. There's no Archimedean point from which a legal theorist can look at the law and cover all the aspects of the law, all the dimensions of the law. We remain prisoners of the legal culture we have internalized, and it's I think it's self-evident that on everything that I write, an effect, a very important effect has been exercised by my background in a German-oriented legal culture, public law culture, where I have been raised and where I have received my education. Two sentences about the two, let's say, methodological devices which I use in the book in trying to examine properties of law. The first device is what I call the ideal type of modern state law. I discuss law in the framework of modern state law, although I at the same time want to emphasize that modern law is just a historical type of law. But I try to justify why I, in a way, am forced to adopt this particular framework. I talk about ideal types, about ideal typical modern state law, and here my reference, of course, is to Max Weber and his methodology of ideal types. I also include in the ideal type of modern state law, and this is of course controversial, but it is important for me also with the view to the discussion in the epilogue about digitalization. I also include in this framework the central features of a democratic Rechtsstaat, or the central features of a rule of law state, or the central features of a constitutional democracy. Well, the ideal type of modern state law is the first methodological device, and the second methodological device is criticism of legal positivism. Discussion with legal positivism, which continues throughout the work, and especially I discuss with Kelsen and Hart, not so much with the disciples, but with the grandmasters of legal positivism. In the text I sent you, you see how I have tried to summarize the central tenets of legal positivism in 6 points, which all may be controversial, but which I try to open up in the coming chapters. But if you want, we can also discuss the way I have understood legal positivism. And a final message, my book can also be seen as an internal criticism of legal positivism, because I consider myself a positivist. I share the starting point that in the era of modern state law, all law is posited law, but I understand the positiveness of law in a way very different from, let's say, Kelsen and Hart. I have even published a book called Critical Legal Positivism, and I was actually positively surprised when I noticed that in an article published in 1929, Kelsen too characterized himself as a critical legal positivist. Okay, that's it. Thank you.